I great hesitation in saying this, and certainly, Mr. Duss, you can respond if you want to that. When let me just say this before you respond. I've read over the years a number of your pleadings, both from you and both from those in your office. I'm trying to be careful in the way that I put this. What I read when I received that, I was surprised. Surprised, and I will say a little bit taken aback. Mainly because, and you know me, I'll just be blunt, I expected better from you. So, and I say that not with any thought as to how I would rule on this issue, because that wasn't really what was playing into my mind. I don't know. Just expected better. Go ahead, Mr. Doss.
Thank you. This is not personal, Judge. This is professional.
Which part?
What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century. If I say to an attorney that I'm taken back by what you put in and that I expected better, you can take that however you will. You can defend yourself. You can say I'm all wrong, that I'm washed up, that somehow or another you can say whatever you want. But I don't say it unless I mean it.
Understood.
Go ahead.
Well, I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support, no authority. We sought to have a conversation about that, and there was no conversation to be had with Ms. Tanner. And so the exam ended up being adjourned because Judge Bauer at the moment was not in a position to decide any of this. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE 4482C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say this. All the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. To say to someone, we afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense. Because it's one of those things that once Once the cow has left the barn or the field, it's out. It's just there. And so it doesn't make any sense. Moreover, Mr. Doss, I was a bit surprised by it because your colleague, Mr. Shea, has argued the rape shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever that it does not apply at preliminary examination. Go ahead.
Well, the authority that there is on that issue is to the contrary. I believe it. I put it in writing. I provided the court with the authority. What in fact I did was I did not submit an advocacy piece. I did not. I'm not asking anything of the court. I'm not trying to convince the court of anything. I advised the court on what the law is. I believe I was well within the rules on going about it in that way. As far as now, what Ms. Tanner put on the record earlier, I understood, based on what the law is, that Ms. Tanner on September 23rd was taken an unsupported legal position and was, in a way, misinforming Judge Barr about it and was not having a conversation about it.
What, misinforming Judge Barr that the rape shield applied at preliminary examination?
Yes.
She would be taking a position that has been the long-standing practice in this county. How can you say that she's somehow just come out with something out of thin air? Show me one case, Mr. Doss, in this county where rape shield has not been applied and not stood at preliminary examination.
The aspect that doesn't apply is the mechanism of a motion and offer of proof in MCL 750520J2. That aspect is just not applicable at this stage. It comes into play once the case is bound over. And that's the very issue that Ms. Tanner raised. She approached me asking whether I would elicit any testimony.
So, Mr. Doss, you paint yourself into a corner. Because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in, ever. And then you go ahead and just make your argument in, circuit court. Until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tanner, you will prepare the order. I will sign off, and that is the ruling of the court. Is there anything additional?
Briefly, Your Honor, regarding the date that this is scheduled for, it's November 10th. I will likely be in retrial unless it resolves starting on November 10th. So I was going to see if the court had alternative dates.
Well, the November 10th date is Judge Barr's preliminary exam date, I do believe. Well, what date did it get set for?
November 10th, Your Honor.
Okay, so first of all, there has to be an alternative date. One of the things that occurred, and I don't know if on the scheduling of this, preliminary examinations that week because of Veterans Day, which did not get caught. Normally it would have been Tuesday the 11th. It may have gotten moved to the 10th. However, Judge Barr was not available on the 10th. So the judge that would be available on the 10th is Judge Valvo, but this has been already submitted and he's got some work into it in terms of Judge Barr. There has to be a different date. And
I apologize for interrupting. I was just informed that our witnesses would be available on November 25th, if that's an available.
I'm sorry?
Our witnesses would be available on November 25th, if that's an available date.
That date is not available before Judge Barr. Judge Barr's next date is December 2nd. And just so that I'm clear, he has the 13th, but my understanding is that would not be available that week, so it would be December 2nd. Is there any objection from either side to setting this for December 2nd?
No, Your Honor, that's a good date.
Then preliminary examination of this matter will be adjourned to December 2nd. I will let Judge Barr, my staff will let Judge Barr's staff know that we moved it to that date because he wouldn't have had the 10th in any event. So, we'll do it that way. Anything else?
No, Your Honor.
Thank you.
Thank you.
Court stands adjourned.
Recording stopped.